heard you say public schools and universities are held by a slightly different standard than private institutions. So NYU being a private institution, do you do you think that that case that I mentioned, in which three university students sued their college, which is New York University, for not doing a better job at protecting them against anti-Semitism. What do you think of that case? Is that going to be a harder case for them to prove? Is it less open and shut because it is a public university, a private university?
If I could just take a step back and sort of explain the background for how that case, I think, is it's really important because so Title VI of the Federal Civil Rights Act, if anyone doesn't have the background on that, it requires schools to ensure that their programs and activities are free from harassment, intimidation, and discrimination on the basis of race, color, and national origin. And very importantly, you'll notice it doesn't give the Department of Civil Rights jurisdiction to investigate religious bias, including Judaism. So until 2004, the Office of Civil Rights really didn't investigate anti-Semitism cases. And in 2004, the OCR, the Office of Civil Rights, issued a series of policy statements announcing that henceforth they would investigate anti-Semitism complaints to the extent that the implicated ethnic or ancestral bias. Because the truth is, most of the discrimination we're seeing has nothing to do with someone does or does not light Shabbat candles every Friday night. It has to do with a real or perceived connection to, for example, the state of Israel. That policy announcement is nowadays known as the Marcus Doctrine, after Ken Marcus, who is the director of the Brandeis Center, where I'm also a senior counsel. And that idea, by the way, has been confirmed in both Title VI and Title VII cases in court. And so schools should be really putting that into practice as well. But it left a small hole in discrimination law, because even though anti-Semitism now fell under Title VI, it wasn't always clear what anti-Semitism actually meant. Without a definition, it's very hard to fight something. So in 2019, with Executive Order 13899, the federal government adopted the International Holocaust Remembrance Alliance definition, the gold standard international definition of anti-Semitism, to be used to determine the intent in those kinds of cases. And schools like NYU, for some reason, have been hesitant to do that, have been hesitant to actually, every year they sign an affirmation saying that they're going to abide by Title VI, including all of the rules and regulations. And 3 times this year already, in January, in May, and just again on November 7th, the Department of Education has released statements saying when you investigate anti-Semitism, among the resources you need to look at are the International Holocaust Remembrance Alliance definition. So this case, a lot of it focuses on really applying Title VI as it should be applied. So it's groundbreaking in the sense that it'll hopefully be the first time that a federal court actually holds this standard to be enforceable.